Welcome back to People's Law School. John attended University of Alabama and Athens State College. He graduated from Miles School of Law. He is married to Kristen, and they also have a brand new baby named Winifred McKay Brinkley. He is a member or associate of our firm, and it's a pleasure for me to introduce John Brinkley.
Welcome to the People's Law School. If you're here because of a DUI or a speeding ticket, you're in the wrong room. Even though this may have been where you were originally if you did get that speeding ticket or the DUI. I'm here to talk to you all tonight about defenses to crimes. And there are some handouts in your book. You may flip through them as I talk along, but mainly probably be easier on you guys just to follow along with my mouth as opposed to trying to keep up with your finger as you read. The first thing I'm going to talk about, like I said, are the criminal laws here in the state of Alabama. They're codified, meaning somebody else, not the judges, decided things were wrong. And those people were called the legislature, and they put it in the Code of Alabama. Is there anybody here who can think of any defenses or any potential defenses to any crimes? Anyone? Insanity, there's one.
Hard to prove.
She says it's hard to prove. Any other potential defenses?
Illness,
Illness.
capacity,
There are a whole lot of them out there, but the main ones we're going to cover tonight are insanity or mental disease or defect, intoxication, and immaturity. The first one we're going to talk about, I said, is mental disease or defect. This insanity plea, while it seems like it makes sense in every movie or television show that you may see on whatever screen, it's really hard to prove. You can't just say, "Oh, I was crazy. I didn't know what I was doing." That really doesn't fly so often here in the conservative state of Alabama. The hurdle that you have to clear is that the defendant, because of the severe disease or defect, was unable to appreciate the nature and quality or the wrongfulness of their acts. And that may seem like, oh, well, that's going to be pretty easy to do, but we're all presumed to be sane. And we're all presumed to know the law, so you can't just say, oh, well, I didn't know that that was illegal or improper for me to do. So that's a pretty high burden for the defendant to try to meet, even though it looks so easy on television. The hurdle, while I did say it was high, for the insanity defense, you have to meet the preponderance of the evidence standard. And that's been in some case law here in the state of Alabama. The next thing we're going to talk about are just some facts that go along or some situations where insanity does come about. Somebody goes in, they don't know what they're doing, and they commit a crime. They say, oh, well, I'm bipolar, manic depressive, or whatever the situation is. I was off my meds. Well, you have to have a doctor or a psychiatrist or psychologist come in and say that, yes, you did need medication, and Lord knows there are plenty of under-medicated people in society, but you have to really be needing medication. You have to be way off your rocker for this to work. There are some people that do successfully use this plea, but it isn't very frequent. Some other people have gone so far as to say that, oh, I was temporarily insane. Usually I'm normal, but during this situation, I flipped my lid. Back about 30 years ago, I'll tell you this one little war story there. I'll try to avoid them as best I can, but I do think this one's cute. The district attorney, Fred Simpson, here in Huntsville, Madison County, he represented, or actually he wasn't the district attorney then. He was defending a defendant, and a gentleman had brought his girlfriend home to meet his wife. And you see where this one's going. She didn't like it so much that this other young lady had come over to meet her at her home, and she did the next thing that you can imagine, and that was to kill her. And Mr. Simpson was questioned by a newspaper reporter thereafter and says, "Lawyer, how do you feel about allowing a murderer to go free?" And he says to the reporter, "The jury found that the defendant did not commit murder, but that the victim committed suicide." And so that one, while may not have been exactly what the jury found, was actually what he answered to the reporter, and I did think that was cute. I did tell you that the insanity defense has to be proven by a preponderance of the evidence and to the reasonable satisfaction of the jury. Now we're going to use this word reasonable pretty frequently here tonight. And as I look around the room, I see plenty of reasonable people out here. And if you go home to my house, let me assure you that everybody there is reasonable, with the exception of me. But reasonable in the eyes of the law is what an ordinary, prudent person would do under the same or similar circumstances. And that's a mouthful, but we'll probably go over that, and you'll have it committed to memory. I'm going to say it so frequently tonight. The next one that we're going to talk about on these defenses is intoxication. And here in this day and age, especially with the drug epidemic that's going on, there are a lot of people that are medicated or intoxicated as they're wandering around with us. Intoxication is not always going to be a defense to any crime. Mainly it will be used in situations where you are so wasted or the defendant is so intoxicated that they are not able to create the mental intent, which is an element of the crime. There are different types of intoxications. One of them is involuntary intoxication, where somebody spikes your drink, drugs you, or what have you. And then the other one is voluntary intoxication, where you did the drinking or the drugging on your own. Obviously, the second really doesn't create so much of an excuse when you say, "Yeah, I drank all those beers, and I didn't really mean it," because that doesn't really hold up so well here in the state of Alabama. Next, we're going to move on to immaturity. And I know that was thrown around a lot when I was growing up in school, immaturity. But what that really has to do with was how old you have to be in order to commit a crime. Here in Alabama, they've decided that if you're under the age of 7, you can't create the intent required to commit a crime. After the age of 7 and up to the age of 14, there's a rebuttable presumption that says that you can create the intent required here to commit the crime. Over the age of 14, you are presumed to know what you're doing, and the intent is able to be proved by the prosecution. Do we have any questions so far on insanity, intoxication, or immaturity? Go ahead.
On your immaturity, you talked about physical age. What about mental capability?
The question is physical age as compared to emotional or mental age. Here in Alabama, the physical age obviously plays the first role in the answer to that question. Now, obviously, there are some people with different types of disorders where somebody could be 50, 60 years old but have the mind of a 9-year-old. That person would have to be evaluated by a physician or a psychiatrist or psychologist, and they would determine whether or not that person was capable of creating the intent necessary to commit the crime. Good question. Any others? The next one we're going to talk about is probably one that most people have questions about. It's the use of force. When can I kill somebody? That's the one that people really want to know about. I know y'all really didn't want to ask that question, so I'll just ask it out loud. When can I hurt somebody? And here in Alabama, there are situations where you can protect yourself. We call that self-defense, or protect other people. here they have, they call it the use of force in defense of a person. It says that a person is justified in using physical force against somebody else to protect themselves or a third person when they reasonably believe that that degree of force is necessary under the circumstances. The good one that everybody really wants to know about is deadly physical force. Deadly physical force. You can only use that in certain circumstances, obviously. Homicide here in the state of Alabama is taken pretty seriously. There are 4 different types of homicides here in Alabama. First one's capital murder. Second one is murder. Third one is manslaughter. And the third one is criminally negligent homicide. And they vary in degrees based on the intent. Capital murder is a special animal in and of itself, and I'm not even going to get into that tonight. But the murder has to do with an intentional act. The manslaughter is reckless, and obviously negligent. The negligence plays the part in the criminally negligent homicide. Each one of them carry different weights or lengths of time that you may spend behind bars. The criminally negligent homicide is a Class A misdemeanor, unless you've been drinking and driving in certain other circumstances where it would roll it up to a Class C felony. The manslaughter is a Class B felony, and murder is a Class A felony. And they vary in lengths of time, like I said, behind bars, and I'm going to read them off to you here very quickly. Thought it was going to do quickly. A Class A felony is for life or not more than 99 years or less than 10 years. So that's 10 to life. Class B felony is not more than 20 years or less than 2 years, so 2 to 20. And a Class C felony is not more than 10 years or less than 1 year and 1 day, so 1 year to 10. Now, there are different types of enhancements when you're talking about lengths of time. These lengths of time that I've just given you are presuming that you've never done anything wrong before. If you have any prior convictions, there is a habitual felony statute or a habitual offender statute that enhances the amount of time that you do get. Also, if you use a weapon, you can tack on another 10 years on each of those types of counts. Let's say you're sitting in your home and somebody tries to bust in there. What can you do? Well, you don't have to retreat here in the state of Alabama. If you're sitting in your home, you can use any degree of force that's reasonably necessary. And don't think that I'm sitting up here and telling you that you can just bust up and kill anybody that comes into your house. Your fear has to be reasonable to the extent that you were fearful for your own life and your own safety within your home. This also applies if you're in your workplace. You don't have to retreat. If you see somebody about to hit, let's say you see somebody who's about to shoot me, you can shoot them. It's kind of like don't bring a gun to a knife fight, or a knife to a gun fight, rather. If you can protect somebody else when you are reasonably certain that harm is about to occur, you can help. You can come to the aid of others. Now, there are some civil liabilities that go along with this. Let's say you make a mistake. You are potentially liable for the harm that you may cause. Granted, you may not be criminally liable, but you could be civilly liable. They could get you get money out of your pocket and not put you behind bars if you were wrong. There are places where using physical force is not justifiable. If I provoke you, I can't say, oh, well, I was acting in self-defense. That only makes sense that if I'm antagonizing you to the point that you want to knock me out, I can't just clobber you with a stick. The only time that situation does occur when it is justifiable, if you are the initial aggressor, is if you, quote, withdraw. And I'm not so sure that that happens too regularly, where if I provoke you and you're coming after me and I try to flee and I say, I withdraw, or I didn't mean it, and then I act in self-defense, sometimes that would fly, but not usually here in Alabama. You can't provoke somebody and then act like I was acting in self-defense to clobber them. Do we have any questions on the physical force?
Most likely you are aware of some legislation that is being reading about relevant to the situation. How does that differ from the current law?
The gentleman's asking about pending legislation on these statutes that I'm talking to you about. Obviously, there's always going to be potential changes in the law. Right now, I'm talking the laws that I'm reading to you are current as of right now. If they do change, I'm sure we'll have to get some sort of addendum to the People's Law School handbook that we've handed out here. We won't charge you extra, but we will let you know if they are changed. If something I've said becomes unlawful, obviously we'll need to retract that. Are there any other questions? All right.
Well, I can see protecting life, but not just protecting property. Let's suppose somebody breaks in that they don't know I'm there, and they just steal something and try to get out the door, and then I shoot them. Now that's wrong. Well, they, I was never in any danger. They didn't know I was there. He didn't know I was there, and I'm just getting revenge or something.
Right. Well, you wouldn't want to tell the jury that. She asks. The question was, in protection of property, can you use physical or deadly force? And the answer to that is no. If somebody has gotten away, can you pursue them? You can. It's really not worth it. But there is a famous case called Tennessee versus, is it Williams? It's the fleeing felon, where a criminal was trying to get away from the police, and he was running, and he got to a chain link fence and jumped up on it, and they shot him in the back and killed him. And that's a very famous case that we all study in law school, so I guess it's appropriate that we talk about it here at the People's Law School, where you can't use physical or deadly force against somebody when it's not necessary. Obviously, for these police officers trying to catch this felon, nobody was at risk there, or the police officers were not at risk to use justifiable deadly force. But that is a good question, and it does lead me into one of our next topics, which is going to be the defense of property. Now, when you're dealing with this self-defense, I'll step back a little bit. You have to be in immediate, imminent danger. I can't walk up to you and say, I'm going to kill you tomorrow, and you pull out a gun and shoot me. The threat has to be right then, right there, at that moment, for the justifiable homicide or the justifiable defense to work. Even if you honestly believe that I was going to kill you, if it's unreasonable, it's still not good in the state of Alabama. It has to be a reasonable belief, not just an honest belief on your part. Let's see. Again, these are affirmative defenses that I'm talking to y'all tonight about, meaning the defendant must prove each of these elements of the defense in order to justify it. Obviously, you've been charged with murder. You have to say, well, it was in self-defense. They're not going to say, oh, okay, it was in self-defense, you can go on home. You have to prove that in a court of law. There are some other situations where people can use force. This is in the use of force by persons with parental, custodial, or special responsibilities. Those persons are a parent or guardian or other person can be responsible for the care of a minor or incompetent person, as the question was asked earlier, to maintain discipline or to promote the welfare of the minor or incompetent person. This means you can act in loco parentis. And there have been some cases out there, while I don't suggest for you to jerk a knot in somebody's kid that's acting up nearby, in certain situations, it is acceptable for a non-parent to discipline a child. I'm not talking about bend them over and wear them out, but to make sure that you're looking after the welfare of the child. This is where the teachers come in. This is where the teachers discipline the students. This is where the loophole is. I know that they can't do corporal punishment anymore in schools, but this is how they're able to get away with disciplining and getting on to children in school. A warden or other authorized official, obviously, the warden's got to be in charge of the prisoners, and he can do anything that he sees fit to maintain the order and discipline by using any type of physical force allowed by law. Another one is a common or contract carrier of persons, like a railroad or an airplane or something to that effect. They can even use deadly force, if need be, to maintain the safety of all the other passengers. Obviously, this would be something that's being used in the airlines these days for potential threats by terrorists. Another time that you can use physical force is if you think somebody's about to commit suicide. You can restrain somebody from committing suicide. You can do anything reasonably necessary, and again, reasonable means what an ordinary prudent person would do under the same or similar circumstances to prevent somebody from committing suicide. Another thing, and this one's pretty good, this is doctors. Doctors can use physical force to treat you. They can do this in two situations. One is if the treatment for the patient is done consensually, or if a reasonable person would do so under the same or similar circumstances. And the real catch in this one that I find interesting is that the doctor can still bill you for his services because doctors don't work for free. So I do think that that's interesting there too. Do we have any other questions here at this point for people who can use physical force? All right, and now we're moving on to defense of property. It says the use of force in defense of premises. The only time that you can really do anything, use force in defending property, is if you see somebody about to commit arson. Or if you see somebody in that house that's about to be harmed by a third party, then you can use physical force. There's a case we study in law school called Ketco versus Brinkley or Burney, and it's the spring gun case. There was a shed out back, and these people knew that vagrants kept coming in there and stealing their stuff, and they set up a shotgun at the front door to protect whatever it was that they had stored in this shed. And when this fella opened the door, shotgun went off and blew off his knee. He wound up suing those people and making more money than he would have had he pawned their goods. So the rule in this is no spring guns, and you can't use physical force to defend property. Do you have any other questions? I know we had somebody mentioned it earlier. Did that spark any other questions for anybody?
Use force on them?
The question is, can you use force against somebody who's trying to hijack your car? Obviously, if somebody's hijacking your car while you're in it, that force that they're using against you, you can use reasonable force back against them to protect yourself or anybody else who may be in that vehicle with you. In that case, it would be reasonable if they pull a gun on you to pull a gun back on them. Obviously, you'd have to have permits galore, but obviously, carjacking is something that people suffer from here in metropolitan areas. I don't think it's quite as safe as it once was to just drive around in your car with the windows rolled down anymore. But if your car is being hijacked, yes, you can use physical force to protect yourself. And again, you would have to affirmatively defend yourself. You couldn't just say, oh, well, I was acting in self-defense. You would have to prove that to a jury. Good question. Any others? Here's one that we're going to talk about. It says, the use of force in making an arrest or preventing an escape. We talked about earlier that the fleeing felon had gotten away and he clung to the fence and was shot in the back. Now, police officers are authorized by law to use force to apprehend the potential criminals. Obviously, if somebody's resisting arrest, they're going to match the criminal's strength with their own and pin them down or subdue them in whatever method they seems reasonable in that case. Obviously, there have been some cases where some officers have gone a little bit above and beyond the call of duty, and I think that they had to pay the price on that and were sued as a result. Obviously, no city will authorize, or no state rather, will authorize their officers to rough up citizens generally. These police officers do a good job for us here in every municipality and in the states, protecting us and don't do anything to harm us. So we are thankful for them and hope that they continue to use only reasonable force when it is necessary in apprehending people. When can I arrest somebody? I'm not a police officer. I don't know, are there any police officers in here? When can somebody make an arrest or use reasonable force to apprehend a criminal? It says that when they believe it necessary to apprehend this criminal, when they see the crime being committed, they know it's been committed, they can apprehend and arrest a criminal. Now, they have to be right. You can't just think somebody's doing it and tackle them in the store. You have to be correct in assuming that, or making the assumption that somebody has committed a crime. So make sure before you go out there for your citizen's arrest that you're willing to bet your bottom dollar on it, because it's not worth your own life or limb to try to protect somebody else's something. While you are authorized to make citizens' arrests, in my own opinion, it's not worth it out there. Do we have any questions on that? Unless a child is involved, the lady says. Then it would be worth it for you.
How does that play into the Good Samaritan law?
The Good Samaritan law. The Good Samaritan law has to do with, do you owe a duty to other people? No, is the answer. Unless you have an agreement with them, unless you're related to them, or unless, I think that's just about it. You have to have a contractual agreement or some other sort of agreement to be under the fall under the Good Samaritan law, because even if you see a traffic incident occur, you owe no duty to that victim. You don't have to stop and help. You don't have to perform CPR. If you do stop and help, you have created a duty for yourself, and if that person dies, if you do CPR incorrectly and you kill them, you're potentially liable in that circumstance. So you don't owe a duty to anybody in this room. Unfortunately, I know that people go out on a limb and they do good things for people, and I'm sure that everybody appreciates that, but in fact, you don't owe anybody anything except for the government, and we owe them taxes here soon. Any other questions? All right. Obviously, we talked about earlier, you can't resist arrest. You're presumed to know the laws here in the state. These are things that you're just presumed to know here in Alabama. Another potential defense is duress. Does anybody know what duress is? That's where somebody holds a gun to your head and says, you do it or I'll kill you. That is an excuse, an affirmative defense here in the state of Alabama for most crimes, with the exception of killing another person. You can't just go commit homicide. Everybody's life is viewed equally, and who are you to take somebody else's life instead of or allowing yours to be taken? You don't have that authority here in the state of Alabama. Let's see. That in fact, killing another person under duress is expressly prohibited in the state of Alabama. It says the defense provided in this section is unavailable in a prosecution for murder or any killing of another under aggravated circumstances. I guess that's probably the most obvious one. You can't just take somebody else's life. Does anybody have any questions on that, about the duress? He made me marry him? I don't know. The last one I'm going to talk about very briefly, in fact, I'm really not going to talk that much about it, is entrapment. Some of you may recall Mayor Marion Barry out of Washington, D.C. used this as a potential defense in a cocaine situation, I think, or maybe prostitution. I don't remember exactly. It was cocaine, the gentleman says. And another says he's still doing it, but I don't know that to be true. But entrapment is defined as the conception and planning of an offense by an officer and his procurement of its commission by one who would not have perpetrated it except for the trickery, persuasion, or fraud of the officer. That's how entrapment is defined here in the state of Alabama. Now there is one little situation that I'll tell you about. It says the fact that an informer acting on behalf of the state or undercover agent initiates the sale of marijuana alone does not constitute entrapment as a matter of law. So as a matter of law, if you're set up by a rat for selling drugs, that is not entrapment here in the state of Alabama.
DeLorean got away with it.
And John DeLorean got away with it, she says. These guys, some of them are just so tricky they get away with it, but here in Alabama we don't stand for it. I've got a couple of hypotheticals I'm going to go over with you. And I'm going to quiz you on what we've learned so far, so I hope you've been looking and listening. We'll call on some of you if you make eye contact with me while I go over this. Hypothetical number 1 there in the handout. I'm going to read it aloud for those who are watching. The American ship William Brown left Liverpool for Philadelphia on March 13, 1841. It carried 17 crew members and 65 passengers, Scotch and Irish immigrants. On April 19th, near Newfoundland, the ship struck an iceberg and began rapidly filling with water. The longboat and the jollyboat were lowered. The captain, 8 crew members, and 1 passenger got on to the jollyboat. The remaining 9 crew members, including Holmes, a seaman, and 32 passengers got onto the longboat. 31 passengers went down with the ship. 1 passenger had died previously. The longboat leaked and was overcrowded, but it remained afloat for 24 hours. The wind rose and the sea became rough. Following the first mate's directions that man and wife should not be parted and women should be spared, the crew threw 14 male passengers overboard, leaving only 2 men and a small boy on board. 2 women passengers were either thrown over or jumped after their brother. The passengers were not informed or consulted about what was to be done. None of the crew was thrown over. The next morning, the longboat was sighted by a ship, and everyone on board was saved. Holmes was prosecuted for manslaughter of one of the men who was thrown overboard. The most obvious question I had was, why was Holmes prosecuted in this case? And the answer to that one is because he was the only guy that showed up for court. I'll tell you that the prosecution argued in this case that the law regards every man's life as having equal value. They also protested against giving the crew members and seamen the power to make jettison of human beings, as allowing sailors for their own safety to throw overboard whenever they may like, whomever they may like or choose. So basically, these crew members decided to toss everybody but themselves. I guess they were all in the same gang, and they were all going to hopefully make it to shore. And finally, they said that the seamen and the crew members were bound beyond the passenger to encounter the perils of the sea. See, the prosecution was saying, look, you guys are rough, tumble, y'all have been trained in dealing with situations like this. Y'all are the ones that should be dealing with the water and not these people that are merely in your, under your charge as riding on your ship. Their defense attorney says that while people say that you should draw lots in order to determine who it is that's supposed to be thrown overboard, they decided that the defense attorney for the crew members decided that that their firm principle of husband and wife should not be separated and that women should be spared was better than drawing lots. They said that that was obviously the most humane thing to do, and that in the middle of the night on a sinking ship, who in their right mind is going to remember we need to draw lots? And so that this principle that the first mate applied in tossing people overboard was the best thing to do. I'll tell you that their last point that the defense had was that the sailor was no longer a sailor, but a drowning man, as was everybody else on that ship. The judge was unimpressed by the defense. He says that unless all ordinary means of self-preservation have been exhausted, you can't decide to do this. Can anybody think of what we've talked about tonight, rule of law here in the state of Alabama, that would cover this? It's the one that talks about the common carrier. They can do whatever they need to protect human life. In this case, everybody's lives were equal. And in this case, they were supposed to have drawn lots to decide who it was to be jettisoned and who it was that was going to remain on the boat. The passenger owed no duty to anybody on that boat, but that the crew members did owe a duty to the passengers. Even the Irish. He says even the Irish. The seamen got in trouble because they placed a greater value on their life than the passengers, which they had a duty to protect. That these drawing of lots was an appeal. The God decided that the fairest mode and in some sort an appeal to God would determine who got to stay and who had to go. Only in this case where the circumstances were so great would a justifiable homicide be allowable. Do y'all have any questions on this little hypothetical that I've talked about?
In this case, we're saying that everybody's equal, but if you draw lots, you have to have some able-bodied seamen on that boat to be able to handle the boat. So in a sense, they're not equal.
That's a very good point. The judge also went on to say that the captain and some of the crew members would have to remain in order to maintain order and maintain the ship. In that case, yes, I believe that some people would be unequal or, come again? Exempt from being cast overboard. It seems that the captain would go down with his ship, but I guess the captain just got lucky in that situation where he would get to remain on the ship and not jettisoned as they were here. That is a good point. This one, I guess, is particularly relevant in light of what we've had recently there in the Mediterranean with that ship being lost. It goes on to say that the sailor's duty is the protection of the persons entrusted to his care, not their sacrifice, a duty we must again declare in our opinion that rests on him in every emergency of his calling, and from which it would be senseless indeed to absolve him exactly at those when the objection most needed. Each one of these cases is obviously fact-sensitive with a justifiable homicide. Would it have made a difference if somebody was dying? Somebody was old, young, a convict, a believer in heaven, a public official, maybe, the president, or even a great artist. Each of those would play into the role, whether or not the homicide would be justified. I've got a little more time. I'm going to do one more very quickly. I'm going to do hypothetical. Let's see here. We do have a question.
As a result of the trial, what decision
The
did
trial on the boat sinking is that the verdict was, or the ruling by the judge was that, in fact, they did have to draw lots to determine, or they should have drawn lots to determine who it was that would have been cast aside, and not the principle that the first mate, I guess, put into effect. let's see. We're going to do hypothetical number 2. We'll just move straight through that. This one's called the Queen versus Dudley and Stevens. It reads, the private yacht, Mignette, sailed from Southampton on May 19, 1884, bound for Sydney, Australia, where it was to be delivered to its owner. There were 4 persons on board, all members of the crew. Dudley, the captain, Stevens, the mate, Brooks, the seaman, and Parker, a 17-year-old boy. The yacht went down in the South Atlantic, and the men and the boy put off in a 13-foot lifeboat. After 20 days in the boat, during which they had no fresh water except rainwater, and during the last day they had no food, Dudley, with Stevens' assent, killed the boy. Brooks objected. Thereafter, all 3 fed on the body of the boy for 4 days. On the 5th day, they were rescued. According to the jury's special verdict, there was no likelihood that any of them would have survived unless one were killed and eaten, and so it appeared to the men. Obviously, that was their testimony. The 2 defendants, Dudley and Stevens, were convicted of murder, then a capital crime in England. Their sentences were commuted to 6 months in prison. Who has any idea how the judge ruled in this case? Who knows why there were only 2 that were convicted in this circumstance? That's right, because Brooks did not agree to kill the boy. And we're not sure how the judge would have ruled.
He didn't eat him either.
Well, he did eat him. That's the thing. That's the snag. Brooks did fill his belly with the body of this boy, but he wasn't tried for murder, which I did find interesting in this case.
Well,
We better
you know,
know.
even he should have been at least an accessory, even if he didn't agree to it. He did eat.
That's right. That's right. So obviously there are some crazy other circumstances that could have gone on with this. Some of the questions that may be asking, did Brooks eat the boy? Should he have been denied parts of the boy since he didn't agree to kill him? So they recognize he objected to it, but then they let him do it. Or is he an accomplice in this? There are many different questions that one could ask, and I think we do have enough time for one more hypothetical. It's obviously hypothetical number 3. And this one is from South Vietnam in 1966. This one's a little bit lengthy, so I'll read fast. Defense Department officials confirmed today that some South Vietnamese troops had been shot by their American and Vietnamese comrades when they overloaded evacuation helicopters after the outpost at A Shau had been overrun by enemy forces last week. The officials said that 7 South Vietnamese soldiers had been killed by co-defenders of the post as a last-ditch resort to permit evacuation of the wounded. The Vietnamese had overloaded the helicopters so they could not take off and disregarded orders to get off. On the basis of information supplied by the United States Military Command at Saigon, defense officials reported that on the first day of evacuation, which was supposed to have been reserved for the wounded, some able-bodied members of the defense group rushed onto the helicopters before the wounded could be taken aboard. As a result, the helicopters became so overloaded, it was reported, that they could not take off. The American Special Forces and the Nung, the Vietnamese troops, had to forcefully remove some of the militiamen. According to the report, about 7 militiamen who were clinging to the helicopters were killed. It was not clear from the report whether the shots were fired from the American or the Nung forces. The extreme measures apparently had the disciplinary effect, for on the second day, the evacuation was reported to have proceeded smoothly, with the operations kept under control by Nung forces. But on the third and final day of the evacuation, the militiamen were reported to have panicked again. Although there were sufficient helicopters to remove all the survivors, fighting broke out within the defense group for seats on the aircraft. During the fighting, one of the militiamen threw a grenade, wounding several of his comrades. Obviously, these people were not aware of the casting lots case that came about 100 years before. While that would have been the best thing to do under those extreme circumstances, it was every man for himself. And obviously these people may have violated what was authorized by the United States militia by shooting them perhaps off of the, or getting them off of the helicopter in whatever way they saw fit so that they could escape. Do we have any questions on any of these hypotheticals?
Just an observation because of this helicopter story. If we go back to the lifeboats, let's say the lifeboats are fully loaded with people, and then you have people in the water who are trying to climb in, and if they're trying to climb in, they're going to swamp the boat. So you beat them off or hit them or whatever, like the helicopter situation.
Right.
So you get some variance in there. Are you obligated to pull them out of the water or not?
Once again, you
To
don't
risk
have an
yourself.
obligation to. The question is,
But you can't once they're in the boat, you can't toss them out. But you can keep them from getting in? That's
I'm
my
not
question.
sure exactly how the answer would go in that circumstance. It depends on who it was that was preventing them from getting in. Obviously, if it was just a passenger, they wouldn't be held to the same duty as would a crew member would. The gentleman asked the question, what happens if you're in a lifeboat and people are scrambling, swimming, I don't guess they're scrambling in the water, swimming in the water towards the lifeboat, trying to climb on board. And if a passenger was preventing another passenger from getting onto the lifeboat, my answer was that they would not be held to the same duty as would a crew member to safeguard their well-being. I do thank y'all for letting me come in here tonight and speak to y'all. I appreciate everybody's time. We look forward to seeing y'all again soon.
In the courtroom, justice is blind. But in our communities, many people seek a different kind of justice, civil justice. The opportunity to have food and shelter, health care, a quality education, a safe environment, and the chance to work. This justice, civil justice, requires that we remove the blindfold and open our eyes to the needs around us. As advocates for justice, lawyers see the needs of Alabama's children and families every day. In the early 90s, attorney Bob Roden, at that time a committee chair of the Alabama Trial Lawyers Association, saw a way for those who often represent the least fortunate to help them more directly. His plan, supported by the association, authorized lawyers to allocate interest from their trust accounts to a nonprofit foundation created to serve the state's most vulnerable citizens. In 1992, the Alabama Civil Justice Foundation was born. By providing funds to charitable organizations throughout the state, the foundation provides a way for lawyers to reach outside the courtroom and into the community to help solve and prevent many of the tragedies threatening the well-being of our state's neediest citizens. Participation has grown from 50 attorneys in 1993 to nearly 1,000 today. Grants have been awarded to hundreds of worthy organizations serving the needs of the disadvantaged, disabled, and at risk. Through the collaboration of many individuals and agencies, the foundation serves a vision of civil justice that embraces all humanity. The hands of justice comfort and heal, build on our strengths as individuals and as communities, make the small gestures that lead to big differences.
I was in second grade. I had just started school and I had this special teacher named Miss Cook, and we were at my lunchtime. And then these DHR people come in and took me, and I put up the biggest fight getting in the car. I think they had to use a crowbar to put me in there. I wouldn't want to go in there, and they took me off. I went from 6 different foster homes in 1 month. One lady kept me for a day and shipped me off. Then I ended up here. been here ever since.
We've been in existence now for over 130 years. Presbyterian Home is not an orphanage. It's a therapeutically oriented program to serve emotional and spiritual and psychological and social needs of the whole person. The Alabama Civil Justice Foundation's grant to us was a godsend. We have computers at Hope Academy that are the very center of the educational process. They're an indispensable tool.
I used to make like F's and D's. Now I'm like a straight A and B student. I would rather go to this school than any school in the world.
From large programs to smaller ones, the organizations supported by the foundation are making a tremendous difference in the lives of thousands of our state's neediest citizens. What does it take to make a difference? What does a foundation grant mean to the people who benefit from them? The voice of justice speaks from the heart.
That's about the only thing I'd want to change with my life, was to know who my father was.
Expresses hope and possibility.
And it was just a great feeling because I said to myself, I finally won, I got him.
Leads to understanding. Connects us all.
I just enjoy being over here with other kids and grown-ups that have the same disability as I do, so I can learn different sports from them.
And often needs no words at all.
I would ask you just to keep this in mind when you encounter lawyers, and you'll probably have to hire a lawyer sometime in your lifetime. I think most of us have to. And when you decide to hire a lawyer, I've got a good acid test you can ask this lawyer. And see if you agree, Alan. It's a simple question. Is law a business or is it a calling? If the lawyer says it's a business, don't walk from that lawyer, run. Because if it's not a calling to that lawyer, he should not be your lawyer. And you know, when you think about it, what protections do we have? You know, you can read in the press how people's rights are being taken away every day at the state and federal level. And you know, to paraphrase Edmund Burke, all evil needs to triumph is for all good trial lawyers to do nothing, because we protect you from evil. And you know, another point I would make, and just to paraphrase Wordsworth a little bit, trial lawyers, and we in general, we're all architects of our own fate working in these walls of time. Some people can do deeds big and great, like we'll talk about tonight. Most are relegated to ornaments of rhyme. And so that's the challenge of all of us in our callings. And I put to you that the trial lawyers in this case have shown us the way, how to lead a good life and how to help others, which is the object of everyone's life. And so to begin our celebration, as it were, I'd like to introduce Sue McGinnish. Sue ran the Children's Trust Fund for 6 years. She now runs the Civil Justice Foundation, which has made grants of $5 million to children, and it's been endowed by trial lawyers.
I'm going to start off with a little explanation of how all this happened, and I really appreciate the opportunity to be here. I've watched People's Law School a lot of times and find it to be always informative. I am the executive director of the Alabama Civil Justice Foundation, as Ed told you, and that foundation was created in 1993 by the members of the Alabama Trial Lawyers Association. What they found out at that time was that they were working very hard to be able to gain civil justice for individuals and citizens within a courtroom. But civil justice was something that needed to be found outside the courtroom as well. And they brought that same spirit and energy to trying to find a way where they could have more of an impact outside the courtroom as well as inside the courtroom. Now, civil justice outside the courtroom looks a little bit like this, or at least it did to them. And that was, it had civil justice. If you have civil justice, you'll have adequate food and shelter. You'll have quality education opportunities. You'll have good health care. You will have a sense of well-being, and you will have an opportunity to earn a living. Now, those were the kind of things they thought citizens, all citizens outside, should have in a society. And so they established this foundation, the Alabama Civil Justice Foundation, that would raise funds and then would turn around and give back to communities through nonprofits, those nonprofit community-based organizations that were working to bring about those things that they thought would build a civil and a just society.